Well, good afternoon, everybody. In order to wrap up the presentational part of the session, at least with the exception, of course, of Olivier Gasson, who's to follow, I thought I'd contextualise some of the discussion that we're having about cross-border regulation of financial markets by reference to some of the things that we're observing in the financial markets right now and their relationship with the cross-border regulatory dialogue. It's not a big surprise that both the European Union and the United States in particular has a pretty expansive cross-border approach to the regulation of financial markets. The underlying markets themselves are, of course, global in nature. Market shocks don't respect national boundaries, and so it's inevitable that regulation on both sides of the Atlantic is likely to be fairly expansive in terms of its territorial scope. That said, I think the success or otherwise of the dialogue between the United States and the European Commission, particularly the CFTC, in reaching agreements on some of these areas of common interest in financial regulation has been quite checkered in certain respects, although there are exceptions. There's been very limited success at all. Now, the consequence of that can vary. Simon made reference to some of the consequences that flow from that difficulty or tension. They can relate to duplicative regulatory compliance obligations being visited upon the firms that are subject to both sets of rules. That of itself is not necessarily a problem, though it does introduce very inefficient additional compliance cost and, importantly, opacity for the customers of the firms concerned. More important is when one encounters issues of conflict of law, where compliance with one regulatory regime is simply incompatible with compliance with another, in circumstances where a firm that is subject to regulation is caught both by CFTC and European Union rules. I mean, that many instances to date of conflict, but there have been a few, and the indications are not good in terms of the forward-looking agenda as we think about mandatory clearing and the implementation of MiFID/MiFIR in the EU. We did encounter conflict around trade reporting, conflict specifically with data privacy laws. The EMIR regulation made specific provision to deal with conflicts between reporting obligations under EMIR and data privacy laws. But of course, for all of those firms that were subject to Dodd-Frank data reporting of almost identical data, EMIR was silent and the conflict arose. It took intervention in the form of relief from the CFTC to mitigate that problem, but it's still a live issue. And as we look forward to the introduction of the clearing mandate in Europe, so the potential for that conflict to arise represents itself pending the outcome of any kind of successful dialogue with the United States. Now, clearly, this is not an exclusively European Union-United States dialogue. There's been much more success, it's worth noting, in relation to recognition, particularly of clearinghouses across Asia-Pacific by the European authorities. So there has been some success. But quite frankly, the elephant in the room when it comes to financial markets is, of course, the transatlantic relationship and the position of the United States, which in terms of market share alongside the European Union, of course, is dominant. But there's a third element I want to just touch upon, which is how this tension in terms of cross-border regulatory tension can translate into underlying market liquidity and resilience risk. And it's in that respect that I thought it was worth just sharing a couple of examples of events that we've seen in the markets over the last 6 months, which bear testimony to the fact that there is already some liquidity-related stress in the European and global financial markets. The issue here is that the success or otherwise of the cross-border dialogue as it relates to impact on liquidity conditions has to be looked at in the round of the wider set of predominantly prudential regulatory reforms which we've seen in the aftermath of the financial crisis. First amongst those is probably the impact of leverage ratio on bank balance sheet, but on a forward-looking basis, impact of regulations relating to things like net stable funding, both of which in isolation have an entirely intellectually sound policy underpinning, but which do have an impact in terms of the consequences as it relates to market liquidity conditions. We've already seen a very substantial contraction in bank balance sheet throughout the European Union, and also a very substantial restriction in the flexibility of that bank balance sheet. Fixed income inventory holdings across the banking sector as a whole are very substantially reduced relative to 2008-9. In certain respects, that may be welcome, but we've seen a number of examples where that stressed inventory and reduced balance sheet capacity has had a meaningful impact in the market. If you look at the October 15 crash on US Treasury yields, a drop of 34 basis points in 10 minutes, which is almost unprecedented, was that caused by regulatory reform? No, of course it wasn't. Reassessment of timing and scale of Fed rate hikes, deterioration in macroeconomic outlook, concerns about the strong dollar's impact on inflation were the reason why there was a migration around US Treasury. But the scale and extent of the market reaction and the price movement was very much a function of the lack of balance sheet capacity on the part of the banks to be able to intervene and intermediate risk. More recently, in March of this year, quite interesting events in the overnight yen market as large institutional clients, asset managers, pension funds look to roll their yen-dollar positions. Again, lack of balance sheet capacity meant that there was very little intermediation of risk took place on the part of the banking sector. We saw implied US dollar rates move out to 45%. They're normally at about 0.07 to 0.65, so very substantial increase in the implied rates, which told a story about the lack of availability in liquidity in that market, which is an absolute standard contract product. It's by no means esoteric or perceived to be high risk. I do sometimes hear commentators say that as the banks scale back their activity in some of the financial markets in terms of the provision of liquidity, so we'll see other parts of the financial market step in and fill that gap. We haven't really seen any evidence whatsoever of that to date. It may well happen, but it certainly hasn't happened as at June 2015. So turning specifically to additional sources of fragmentation as it relates to the cross-border dialogue, I mentioned before that the relationship between the CFTC and the European Commission in taking forward equivalence and substituted compliance discussions as it relates to the international swaps agenda has been met with checkered success. I think that is a charitable way to describe the status of that dialogue so far. I don't want to paint an entirely unhappy picture in terms of the transatlantic dialogue. I think some of the work which has been done in conjunction with the Federal Reserve around non-cleared margin is pretty positive. I think the daylight between the European Union and the United States on some of those issues is less, although there are still some significant issues. But as it relates to matters that are contemplated by other parts of Title VII of Dodd-Frank, which relates to swaps reform and various aspects of EMIR and MiFID on a forward-looking basis, it doesn't look so good. We don't have the recognition of clearinghouses in the United States, which is a very big deal on a number of levels, given the international nature of the market, which is supported by those clearinghouses. And when we look forward to various other aspects of the implementation of EMIR, the fact that we don't have any Article 13 equivalence yet for the United States, or quite frankly elsewhere, is also highly problematic. It's not a European story alone, and certainly my comments shouldn't be construed as a criticism of the European approach here. I think it's testament to the difficulty in reaching agreement where both the European entities and their counterparts in the United States are looking to adhere to standards which have been set domestically by reference to their own legislative processes without necessarily adequate due regard in advance for how those underlying rules which emanate from those legislative processes will work or not on a cross-border basis. In the United States, for example, we see instances of trapped capital as the product of Section 165 of the Dodd-Frank Act, which takes capital out of European entities that are operating in the United States and requires it to be trapped onshore in the United States. The Volcker rule is very extraterritorial in terms of its impact around the world. And there are various other concerns that emanate from the US approach to the cross-border regulation of swaps more generally, which is complicated by the fact that the CFTC and the SEC don't have the same approach either. So it isn't a case of what is the United States position versus that of the European Union. The United States does not have a position as such because it is down to each of the agencies in question to determine their own approach to some of these cross-border questions. So where does it take us? It takes us to a place, I think, of regulatory uncertainty. And if you ask a lot of people what their key concerns are about the next 18, 24, 36 months in this space, I think often the answer goes back to that central point. It's lack of certainty as to where we're going to land on some of these points. What are the solutions? Well, I don't think there are any that are particularly straightforward, but I agree with some of the comments of the previous speakers in terms of some of the suggestions that we might adopt. I think a very early and focused, dedicated concentration on third country impact early on in the legislative process would be very welcome and not necessarily hugely difficult to deliver. I think looking at the role that the likes of the Financial Stability Board, Basel, IOSCO do and can play in terms of driving international standards is welcome. There are always realistically going to be limits on the extent to which those international bodies which don't have parliamentary mandates behind them, there's always going to be a limit on the extent to which they can fulfil this role. That I don't think, though, is inconsistent with them trying to drive a slightly more granular level of formulation of standards at the international level for further consideration then by respective legislators around the world. And there have been successes there. I think the work that I mentioned earlier of IOSCO in the context of non-cleared margin has been pretty successful. I think some of the work of the Basel Committee, although it has its detractors, has also been largely successful as well. But there is a lot more to do. And my final comment is perhaps to reinforce the commitment which has been expressed by many on both sides of the Atlantic to consider an outcomes-based approach when it comes to this question of equivalence determinations and substitute compliance, if you use the US speak. I think there is genuine willingness on the part of all of those regulators that I've spoken to find agreement. So, as I say, my observation shouldn't be taken as a criticism of either the institutions or the individuals, many of whom I know are working tirelessly to come to successful outcomes on some of these issues. But the fact nonetheless remains that I think there is uncertainty as to what an outcomes-based approach in fact means. And as a consequence, when we look at the progress that we've made as at June 2015, certainly as it relates to swaps markets, I'd say that progress, regrettably, has been somewhat limited. So I'll leave my comments there.